welcome to another episode of Friends of the Court, Law Made Easy. I'm your host, Ian Snow, with co-host George Bassias and our special guest, Michael Delakis, Esq. Welcome, Michael. Thank you for coming to the program.
Thanks for having me.
Please tell us a bit about yourself and the areas of law that you practice in.
I've been practicing for about 10 years now. I focus on workers' comp with George sometimes, criminal and family law matters. Yeah, that's pretty much it.
Criminal and family matters as well?
They intertwine.
Okay.
Because sometimes you might have a family law issue, and because violence was used, then it becomes a criminal law issue, order of protections, so they're kind of intertwined. There's different courtrooms, but sometimes they're intertwined.
And how can people get in contact with you?
My phone number is 212-321-0232.
All right. And where is your office?
In Astoria, on Steinway Street.
Okay. And do you have a website or social media presence?
mad911.com.
Now, I did notice on your website that you also practice in the area of estate planning and divorce custody issues, correct?
Well, the custody and divorce kind of fall into family law, even though divorces are basically in Supreme Court. But because there's custody issues and support issues, sometimes when the divorce is over, people have to petition the family court to get an order enforced based on whatever the Supreme Court says.
George, would you like to add anything?
Yeah, there's a couple of things. This particular segment will focus in on criminal law, on driving while intoxicated and driving while under the influence. Michael has a double whammy of experience in the area of criminal law. What I mean by that is a former retired police officer for the NYPD, detective, and he's a specialist in criminal law. One of the things I'd like to say, I'm a licensed attorney in the state of New York. Michael is a licensed attorney in the state of New York. And what we will be discussing today, we're discussing generally. If you have a particular situation that involves the area of discussion that we're in, our advice is to you to get your own counsel, because every case is different in its own specificity. There are things that are in your case that may not apply to the general discussion that we're having. So my advice to you is either hire your own lawyer or get a lawyer appointed by the court at no charge for you to represent you. Do not try to figure out by yourself. You're taking a big chance. Every now and then I get people coming, telling me about medical issues, what they learned on the internet. You can't do the same thing with law. You just can't. You have to be an attorney to understand how the system works. So our advice is get your own attorney, but please enjoy the segment on this discussion on driving under the influence and driving while intoxicated.
Yeah, and to continue with that, George, driving while intoxicated or having an accident while after having had a few drinks happens to the best of people. And even in the news recently, the husband of the Speaker of the House recently was arrested for DWI in the Napa Valley in California. So it can happen to anybody. Michael, could you please tell the listeners the difference between a DWAI charge and a DUI charge?
So there's a statutory where if the breathalyzer says that you're 0.08 or above, you are driving while intoxicated. Anything below 0.08 could be driving while ability impaired. I believe it's up to 0.05 to 0.07.9 or something to that effect.
I see. So it's a matter of alcohol content with the breathalyzer.
Yes, but however, DWAI is a violation of the penal law. It is not a crime. So you would still get arrested. You would still have to answer in court. You'd still have to abide by what the court tells you. However, the end would be no conviction of a crime. So a lot of people, when they apply for jobs, have you ever been convicted, would be a no. However, DWI, it is a misdemeanor. So if you get convicted of a misdemeanor, usually it's a misdemeanor, it's a crime on your record. And New York doesn't recognize, expunging of records.
Wow, so it's permanently on the record, these tests?
Pretty much. I mean, there's other ways you can get something called disability of in other words, that you're kind of showing the court that, okay, you know what, I made a mistake, but I'm a good guy now, so the court will give you like another chance. But that doesn't mean that the conviction will be taken off.
Yeah. So we've put together some questionnaires from listeners and ourselves. I'll go to our second one. So George, did you want to add anything to what
I'd
Michael
like
said?
So, assuming somebody is a first-time offender, which is the higher charge, the DWI? The misdemeanor charge?
It depends.
Okay.
So it depends on what happens at the inception of the police stopping you, and then what happens subsequently, getting the breathalyzer later.
Okay.
So there can be a situation where, you don't, the officer looks at you and he believes you're intoxicated, and it could be bloodshot eyes, slurred speech, unsteady on its feet, and that's basically the common law.
So if I called you, Michael, if I called you from the scene, I just got pulled over, I just left the bar, and I know I was intoxicated. The cop asked me for my driver's license registration, and I could tell by the way he looks at me, he can clearly tell that I'm drunk. He even asked me if I've been drinking, and I don't answer him. And he goes back to his vehicle, and while he's in his vehicle, I make a quick call to you, and I say, Michael, I'm in trouble. I just got pulled over. I'm really drunk. The police officer can tell that I'm drunk. I think he's going to ask me to do a breathalyzer. What do I do?
All right, that's a very loaded question. Because it all depends on the facts. So let's say you did mention something earlier. Let's say you get into an accident, okay? And let's say you hurt somebody or you kill somebody. I wouldn't take the breathalyzer because you're just giving the state more evidence against you. Because you already have the aggravated DWI because you injured somebody, or worst case scenario, God forbid, you killed them. So you're just basically giving the state more evidence if you breathalyze. Now, would you say do you blow? Is that the question?
Yes. Do I
Okay.
blow?
It depends again. So if you have a CDL, if you have some sort of, if you're a taxi cab driver and you need to drive, if you don't blow, you would get your license suspended for 90 days, right off the top. That also is a problem, like in Nassau County, because Nassau County doesn't negotiate well if you refuse, because the mentality is that driving is a privilege and that you're subject to the breathalyzer. And if you don't breathe, blow into the breathalyzer, they're very resistant to give you a DWI, which is a violation, even if it's your first time arrested. All right, so there's hearings involved in a trial, and they could find you guilty. Some other jurisdictions are different, but you never know. So
What about in Queens?
Queens it varies in Queens too, because again, if you don't blow and provide a reading to the police officer, it depends. Sometimes I can't give you a definitive answer because it depends also on the circumstance of the case, and the district attorney may say, no, we're not doing it, we have to go to a trial.
It sounds to me from what you're saying, if I have a clean record, I'm better off blowing.
Yeah, but I can't tell anybody to do that. So, if you've never been arrested before, but you're also taking the risk too, because if you had 10 drinks and you blow it, 2, not a 0.08 or 0.01 or even a 1, but like double. Sometimes it's aggravated DWI, and then you have more problems. So, I mean, if you had 3 drinks, it also depends on your body too, because I did something called a drinking lab when I worked in the Miami-Dade State Attorney's Office, and basically they allow you to drink, and the new police officers do the tests on you, and I realized that I burned the alcohol fast. So when I blew really high, when they tested me again, I came really low. but I failed the coordination test. And I don't think I failed that much, but, you know, the police officer thought I failed, and so that's what he wrote down, that I failed.
Interesting.
And that is his probable cause, which is needed to arrest me.
Interesting.
Something you said also makes me think in some situations it would be better not to take the test and not just hand over that immediately to the state. What happens if somebody lies and says, I didn't have more than 2 drinks, and later on they find out from a receipt at a bar that they had 6 or 7? Would that work against you in the court that you lied?
Okay, so those are rules of evidence, okay? And the rules of evidence allows extrinsic evidence against you to impeach you, in other words, catch you in a lie. So we're talking at the trial level, all right? But I think everybody's seen enough movies when they tell you, if the police talk to you, don't say anything. Right? I think that's a common thing. But people, I think, is just, you know, general in nature. When they get stopped and they feel like they didn't do anything wrong, they want to explain themselves. But sometimes explaining yourself is, you know, admitting to things. So if you don't say anything, they have nothing to hold against you. I mean, you're required to give your name, you know, where you live, your date of birth, things like that, you know, identification stuff. But other than what happens, you know, they don't. Now, there's also the issue of Miranda. So Miranda has, you know, there's 2 issues. So you have to be in custody and asked incriminating criminal questions. So if the officer does give you Miranda, anything afterwards would be held against you. But that doesn't mean that you have the right to remain silent. That's the first rule in Miranda. You have the right to remain silent. And I suggest people take the right.